Hello and welcome to my presentation. Today I will be discussing paper number 2 from our Language of the Law class, which focuses primarily on trial language and narrative. I was drawn to this particular paper for not only these reasons, but I was also fascinated with the idea of that in trial court, facts do not necessarily matter as much as the narrative itself. The reason for this is that both sides are trying to win their case, and their focus is not to hear the truth, but to poke holes in the witness testimony in order to sway the jury in their favor. The end goal is to discredit the witness in order for their testimony to basically be thrown out. To begin, I want to quickly explain narrative. Author Peter Tiersma states that a narrative begins with an introduction, continues with a chronological sequence of events, builds to a crisis or problem, and ends by offering a solution. The case that I chose to examine for my paper is Hadley v. United States. For those of you who do not remember, this case involved a man named Jerome Hadley, who one night threw a dinner party with his wife Bettia. The evening later turned violent as Jerome, by Pattia's statements, pulled a gun out on her and threatened to kill her. The cross-examination of this case indicates to us that the narrative plays a more important role than hearing the truth. The first example I want to show you is from Mrs. Combs as she's being cross-examined by the defendant's attorney. Pay particular attention to the questions that are being asked and how they're being asked. For example, the first question to Mrs. Combs is, "Now the charges. Did you ever tell the police that Mr. Hadley had held a gun to your head?" To which she replies, "I don't remember what I told the police." His next question is, "You don't remember telling them that he held a gun to your head, correct?" To which he replies, "I don't remember what I," as he quickly intercepts by saying, "So you don't remember running out to them and saying, 'Oh, he's got a gun and he's held a gun to my head?'" To which he replies, "I didn't run out to them." The next question, "You didn't run out?" This is a particular example of the questions that are being asked in order to poke a hole in her testimony. The second example I want to show you is Mrs. Hadley being cross-examined still by Mr. Duggal. Pay closer attention to the type of questions, especially the last question he asks. The first question Mr. Duggal asks Mrs. Hadley is, "Well, did you file charges that he had held a gun to your head?" To which she replies, "I think I did, yes." He questions, "Okay, did you ever see a gun?" To which she replies, "Actually, no, I didn't ever see one." His next question is, "You didn't ever see Mr. Hadley with a gun?" To which he replies, "No, I didn't ever see it." So here's the main question. So if the police said that you saw a gun and everything, then they're mistaken? That last question right there is what stands out the most to me. And the reason for that is that he's not pointing something at her, rather he's just asking her a question, which is putting her on the spot with what she's implying. He wants to discredit her in any way possible, and in turn he is pushing a narrative of his own to indicate to the jury that her testimony is invalid. A narrative becomes the most important factor in a case trial. The facts or information being provided by a witness is only as valuable as it is being used as a tool for the defense to build a narrative around it in order to use the testimony in their favor. In regards to narrative, author Jerome Bruner states that, in order to better understand what exactly a narrative entails in a trial, we also need to understand how facts in a case trial are defined as well. Something that is considered a fact does not necessarily apply in a trial as fact. It is all based on one's choice that plays into a narrative that allows one to explain what happened. In fact, much of human reality and its facts are not merely recounted by narrative, but constituted by it. So upon finishing this paper, overlooking the trial transcript and the wording and the questioning itself, I found this very educational and very informative for me. I've taken previous law classes in the past, but we focus primarily on law instead of the language itself. This class really helped me to understand the language and how basically everything comes together, the types of questions, and how they go about asking them within the case itself. I've learned a lot about language in previous classes, but I've learned a lot about language in regards to the law with this particular class. I feel like this class is going to help me a lot in my future endeavors. I find that this class will be very helpful in helping me as I move forward into working to get into law school. I definitely learned a lot of imperative information in terms of law itself, and basically the law lingo. I'm very excited that I took this class, and I think that this is going to help me out in a very big way. Thank you for watching my presentation, and I hope you have a good day.